Well, the NBA conference is certainly continuing. Started yesterday. The president and a number of dignitaries, as you have heard from that report, were there to open the show, so to speak. And, you know, several issues were raised when the president had that conversation with them, talking about so many times, of course, that he has been according to him, a victim and a beneficiary of the justice system, you know, delayed justice and all of that. But one that is critical that we have talked about at every election period is that of electoral reforms. And it really borders largely on what role the judiciary can play in that. And lawyers definitely are major practitioners.
And, you know, it started on a lighter note saying that, you know, the NBA is older than Nigeria. So it's a big brother to Nigeria. And I think it's instructive, like you said. So the NBA can actually put a lot of things, influence, set the agenda, as it were, for the judiciary to put those things in place. It's kind of gratifying to know that the president actually placed a lot of, you know, responsibility on them with that speech, saying that, you know what, why can't we have shorter time frames for our court proceedings, talked about judges, talked about conflicting court judgments. And I like the fact that it was contextual. It wasn't just some speech taken from somewhere, and, you know, it was something that we've experienced. The president himself has experienced some of these things. And I like the fact that we have an agenda, as it were. And I mean, it is going to be a big task for the NBA to achieve this thing, since it's a big brother, as it says.
Big brother would probably suggest something else entirely. Well, let's take this up with Mr. Según Odubela, Senior Advocate of Nigeria, who joins us virtually. Thank you so much for your time this morning. So the NBA conference has started. The theme is Step Forward. What should we expect?
Well, thank you very much. Good morning, viewers. And I think what we should expect is things that we need, as practitioners, need to put in place to advance the cause of justice. Because above all, the justice is a major issue. Even you can't talk about democracy without talking about rule of law, without talking about justice. So, and if we need to move forward really and actually do exactly what is expected as a body of lawyers, I think we should be concerned, just like the government have put across some of those challenges that we need to actually look into, so that we can actually get to our destination. Because for me as a legal practitioner, I think we're still very far from our destination. So I think what we should look for is that unity and advancing the cause of justice.
For you as a legal practitioner, just as you have put it, what are those challenges you have seen that need to be tackled as urgently as possible?
Well, I think the first thing for me is the delay. And that have actually affected even the economy. For example, I think the major challenge that we have in the cause of delay in our courts is the legal practitioners ourselves. And I'll tell you, you see, and I feel that we should still look for more ways to regulate our conduct, particularly in courts. And the major problem is our conduct. And I'll give an example. A lawyer in a pre-election matter where a party have filed an action, which is time-bound. For example, you have 180 days in a pre-election according to the fourth alteration to the Constitution. And as a plaintiff, you filed your case, the defendants have responded, and it is time the court is ready to hear. And you hear a defendant's lawyer saying that why are you in a hurry? After all, we have 180 days to complete this matter. I mean, for me, what does that portend to me? Portend very serious danger in the practice of law. Because parties are ready. At least you as a plaintiff, you've done all what you needed to do. The defendant have responded. The court was ready. But a defendant will now say that, why are we in a hurry? I mean, in the first place, why are we in court? Is it not for our matter, for our complaints to be determined? And you see, I feel that is a major problem, is the lawyers, the practitioners themselves. So I feel that we need more law or maybe regulations that will conduct and regulate our conduct, particularly in court. And of course,
just one moment. Just one moment. You know, you just raised an issue now that a number of people will probably agree is something that needs to be tackled ASAP, and that is the issue of the conduct of lawyers. And you also cited the case of lawyers taking on time-bound issues, just like that, and in a way, just as you have said, affecting many other things, and obstructs the course of justice for other issues. What kind of recommendations do you think should be made, perhaps by this conference, to ensure that we do not have such cacophony of issues that don't necessarily need to be taken to the courts almost all the time? For instance, we would have a situation where, just as the president cited when he addressed your conference yesterday, so many cases about one issue that perhaps may not necessarily be in the courts. Is it a function of the laws or some lacuna that some people are taking undue advantage of?
Yes, you see, the most important thing, and which I feel that we need to address, is that as lawyers, as practitioners, we need first of all to have a more strict code of conduct. Code of conduct in the sense that if you are a practitioner and you are going to court, you must be ready to have in your mind as paramount the interest of justice, beyond the interest of your client. Of course, you owe your client a duty to do your best in the cause of either you are prosecuting or you are defending his cause. But it shouldn't be above the cause of justice, the general cause of justice. So if you don't even have a good case, it is better to advise your client and explain in detail why he doesn't have a good case and that you need to settle this case, rather than going to court and bringing it several issues of technicalities that will delay and in most cases will destroy the cause of justice. We are not helping the matters at all. And that is why the public opinion against the legal practitioners as of today is not good at all. And that is why there's a need for this conference as a matter of urgency to address these areas of delay. I'm not saying the courts don't also have issues on their own, which are also contributing. But for me, I would say that about 70% of the delay are as caused by the legal practitioners.
You know, when you say that lawyers should actually sit their clients down and be frank with them, saying, I don't think there's a case here, how do you now balance, people saying, would that be shutting the door of the temple of justice, rather, against those people? How do you really balance that? Because everybody should have a right to approach, the temple of justice.
Yes, but it's a two different things entirely. You see, the law as it is there. Let me give you an example. Somebody comes to you and say that, look, I enter into a contract, but for one reason or the other, he didn't come to you until after 6 years, which clearly shows that he has no claim again because that claim is already statute bad. And you now advise him and say, look, clearly it is statute bad. You explain to him that he had not come before the expiration. And as a result, there's no case. But I can tell you that some lawyers, will still go to court and say they want to go and see whether, they could see the best thing they can do to bring that kind of thing to life. And you will take that case from the High Court to the Supreme Court, and at the end of the day, they will still tell you that it is statute bad. There's no solution to it. So look at that case. Take that case as an example now. That case must have delayed the course of justice because it has not given because it will be competing with other cases in the course of the proceedings. Whereas if you have advised such client and the client realize that there's no need to go to court. So it's different from the client not having access to court. Of course, he has access to court, but you should be able to be firm that, look, this case is statute bad. It won't see the light of the day. And it doesn't matter if you leave lawyer A and you go to lawyer B. Lawyer B will still tell you the same thing because that is the law. So in such instance, I don't think that will probably cause any delay in you as a Nigerian or as a citizen in not having access to court is different.
So that raises a question about ethics in the profession, really, and we'll touch on that. But I'm just thinking, so what would be responsible, for example, for a lawyer saying, well, I really know that this might not fly, but let's go ahead. Is it for economic gains, or maybe a young lawyer trying to test the laws and maybe set a precedent and say, well, I have achieved this, in my career? One wonders, is it for economic gains or the other reason, or there's something else that is responsible?
Well, I think it all depends. But I know also that as legal practitioner, you also have instances where you can take advantage of some conflicting decisions of our superior courts. Because you have an instance where the same Supreme Court decision would support A, and probably says, okay, B is not applicable. And then you also see another decision of the same court saying, yes, A is the position, but B is applicable. So maybe a lawyer in that instance may want to try his luck and then say, okay, since these are conflicting decisions, maybe my case can suit in between. And at the end of the day, maybe he may be lucky to find that decisions, and maybe the case at the track will end at the track court and it succeeds. So for me, apart from the economic gain that a lawyer may say, okay, let me go to court. And also, of course, they also take advantage of some of those conflicting decisions. But I think that once we have a reform, and particularly certain ethics that will regulate our conduct, I think that is the starting point. Regulating the conduct of practitioners, particularly in court. I think that will help us in reducing most of these delays in courts.
When you talk about the ethics, what is missing? I know that, your body, lawyers have a code of ethics. So is it a function or a problem of ethics or discipline? Or you've talked about reforms, but are you saying that there is such a huge gap in the reforms that can take or allow these gaps, this unethical behavior, so to speak, to go on, and it has gone on for so long?
Yes, I think is a combination of the point you have raised. But I think the major thing is the enforcement. Because again, you see, for instance, now you will find this difficult.
1 moment. Whose task is it? Whose task is it to enforce, just as you have said?
Well, I think it should be the Bar Council, because I will give you an example. For example, just the one I mentioned in court, where a colleague will tell the court that because you have 180 days, the court should not be in a hurry to hear a case that have been properly brought before a court. You see, and you find it difficult, for example, for me to say I want to go and report such. It may sound that maybe I'm not helping the system, but I tell you, it will be difficult because it will seem that you are just reporting a colleague that is practicing the best way he knows. But that is not the case. The case is that if we have a system where even a judge can report such lawyers to the appropriate body that will discipline that lawyer, or probably we also have members of the disciplinary board even attending courts to even see the attitudes of the lawyers in court, and they begin to implement and punish such lawyers. And I think a lot of us will sit right, because that is the beginning, that is the starting point.
Would you propose then that such a course of action be taken? Plus, I know, of course, you are a senior advocate of Nigeria, and there are several senior advocates of Nigeria. Isn't there a role they can play to ensure that these things do not go on, or are they also culpable?
Well, with due respect, you even find out that some of these attitudes are even exhibited by senior advocates. And that is where I have the problem. And that is where even I will even suggest that even the body of the senior advocate also needs to play a major role in this respect. The body needs to play a major role in this respect. Our conduct needs to be regulated inside court.
Okay. Well, another thing, you talked largely and a lot about the attitude of lawyers and how that is responsible for delay in the delivery of justice. Another one that the president mentioned is that of course, the processes and all of that. Well, the papers are telling us this morning that you have less than 2,000 judges over more than 155,000 cases. As you said, some of them time-bound, some of them time-free. Consequently, they go on for decades in some cases. What do we need to do about both the number of justices or of judges and the selection process of judges?
Yes, thank you very much. I think the first thing is that I agree that in most of our courts, whether trial courts, the middle court, or the Supreme Court, that we don't have enough judges. And that is very important. But again, the facilities are also not available, because you find out that some of the judges are still writing in longhand. You see, first of all, we need to appoint judges. Secondly, we also need to make available facilities that will make their work much easier, particularly in terms of listening to counsel in court and in terms of taking evidence. You see, it will save a lot of time if we have facilities that can only allow or make the judges to just write few points and then go back to listen to the recorded audio of not only the submissions of counsel, but evidence. I think with that, it will lessen their work. Then secondly, is the issue, particularly the Supreme Court. I'm not saying there are no delays in the High Court or in the Court of Appeal, but I think the one that of major concern is the delay in Supreme Court. I mean, I'm sure you are aware that as we speak now, the appeals that are being considered or are being had in Supreme Court are probably 2009 and 2010 appeals. And we're already in 2020. And I think that the major problem we have in Supreme Court first one is the number of justices. Up to, I think as we speak now, there are just about 12. And the full court is about 20. And I can tell you that even at that 20, they are not enough. Especially looking at those appeals that are coming from the High Court to the Supreme Court. And I think again that apart from the fact that we need to amend even our constitutions to allow even beyond 20, except, of course, we're going to also amend our relevant laws to ensure that not all appeals that will get to Supreme Court. But if we still have this open race for a case going from High Court to the Supreme Court, then except we increase the numbers to even up to times 2, maybe by the time we have 40 justices of the Supreme Court, then maybe the lead will be reduced. So I think that is a combination of the appointment and, of course, the facilities that are available.
Right. You know, we've had this conversation several times, and I just wonder, the irony of it all, such a powerful arm of government seems so powerless in, fixing some of these issues. And I'd just like to get your thoughts on this debate we had earlier on the program. So the headline, President Buhari laments slow pace of justice system, seeks reforms. And our guest was like, well, shouldn't it be the president, or at least at that level, that the solution will be proffered? So let me ask you, at whose table is the solution to all these challenges?
Well, if you ask me, I will tell you is the executive. And that is the truth. Now, let's first of all talk about even appointments, the procedures. Now, the NJC recommended certain justices of the Court of Appeal to the Supreme Court. The first set, I think there are about 4. And the second set, I think about 4. The first set, if I'm correct, these recommendations had probably been done almost close to a year, if not even more than that. And then the executive, particularly Mr. President, has not done the needful. Definitely, that cannot be the problem of the judicial arm. They have done their own part. The process has been done, has been concluded, and appropriate recommendations have been done to the executive arm. And by the constitutions, they are to now complete that process. And after which, of course, maybe the swearing in will then take place. So the Supreme Court, they have 12 now, if I'm not mistaken. So where do we go from there? There are still so many appeals. How many panels can you constitute from 12?
Well,
even if you need to constitute 2 panels, let's say a constitutional matter, you cannot even find 2 panels to be constituted from 12.
And talking about constitutional matters, there are so many, critical issues in the Constitution that a number of people, and perhaps you as well, wonder, what can we do about this? But we'll touch on some of these issues when we return from this break. Please stay with us. Thank you for staying with us. Mr. Odubela, so that issue that you raised about the need to tackle this whole justice or judicial reforms issue, you say a large number, a significant number of those issues rest with the executive. Now, is there any way to compel the system, the executive, to do the needful in the interest of justice delivery or in the interest of administration of justice?
Well, thank you very much. Again, because of the position of the judiciary, I don't think that they're in a position to probably go to say they want to challenge the refusal of the executive to complete, for example, the process of the appointment of justices. And I think this is one of the things that the NBA as a body can do. Because, I mean, whether you like it or not, is apart from the fact that the lawyers are also affected, the most affected people are the populace, because they are the ones that have gone to court and they want their matter to be decided one way or the other. But where you don't have those justices, or where they are short in number as to effectively hear those cases, then they are the ones that suffer most. So I think it's the body of the legal practitioner that I think can assist the judiciary in probably enforcing some of those decisions. Because
just one moment, Mr. Odubela, it's been a while that this conversation has been going on. People talking about the need for the NBA to play a prominent role. 2 NBA conferences ago, even the last one, this same issue was raised. What's the delay? Well,
I think it all depends on the executive and the way they say things. If you have an executive that don't think is the problem of the NBA to, for example, ensure that after the recommendations of the NJC, pressures are put on the executive to complete the process so that we can have the court running, then nothing will be done. But if you have an executive who also believe that, look, this is where we practice, this is the last hope of a common man, that is always said. And then such executive will take it up. They will keep on reminding the executive that, look, this process is on your table and there's a need for this process to be completed, because that itself is a major cause of delay in the administration of justice. Because if you don't have a full court, for example, those appeals will just be there. They will just be there.
Well, there are many issues that are...
Some of them, let me quickly make this point. And some of those things even lapse. I'll give you an example. There's a pre-election where a party, a decision was not even a decision, a status quo order was maintained. Was ordered that, okay, no party should do anything until we finish hearing this case. And I tell you now that a lawyer, a party now, appeal to Court of Appeal. And he lost at the Court of Appeal, and he went to Supreme Court. And under default alteration, the appeals should be heard within 60 days. Now, he has caused a major delay at the trial court. The appeal has been lapsed already, because the 60 days from the time of filing his notice of appeal had expired. And I can tell you, for example, that that is automatic. The trial court should then go ahead to proceed with the case. But I can tell you that some of our colleagues will still come to court to say that, no, you still need a positive order from the Supreme Court. And I wonder why we should not be in a position to assist the system of justice. So, and that is why I still feel that the problem is still rests on us as practitioners.
The president asked a simple question, well, a seemingly simple question yesterday, and this was what he asked. Why can't we have time limits? Sounds simple, but is there an answer to that, or what do you think the answer is, really?
Well, you see, for me, it also have advantages and it has disadvantages. And I'll just give you an example now that in a pre-election that has time bounds, for example, at the High Court, you have 180 days. The Court of Appeal, you have 60 days. Supreme Court, you have 60 days. And I'm just giving an example now. And a party who, in the course of even the interlocutory proceedings, took up a point on appeal, he filed stays at the trial court. The Court of Appeal, it has 60 days. He was able to get a decision within that 60 days. Now, he also appealed to Supreme Court. Now, at the Supreme Court, he has also 60 days. But that could not be able, the court could not determine that within 60 days. And the appeal lapsed. So it is easy to do that probably in some of these election matters or maybe in contract. But if you now want to introduce in a criminal trial where you want a time limit, maybe that a trial should be completed, let's say, for within 180 days, and you have some difficulties, maybe some lawyers bringing applications upon applications, and you couldn't complete that within 180 days. What happens to a defendant? Do you set such defendant free? Because you can't bring another charge. That would be double jeopardy. Do you now say that having failed to complete that criminal trial within 180 days and that it will lapse and the defendant set free? So it all depends. Even take, for example, in the pre-election matters or even in the election matters that we do, you will find out that, yes, it has some a lot of advantages. But again, a lawyer who doesn't want the matter to go will frustrate the proceedings, except you have, of course, a reform that will regulate that conduct of that lawyer to the extent that you can even you can impose a high fine, perhaps, and that you don't allow some people to practice until that fine is paid.
Okay. And
you need to also educate the clients that the fines is not meant for them to be paid. It's for it's a personal cost against that lawyer.
Mr. Odubela, you've mentioned a number of examples, and quite a significant number of them have been about the elections, and which leads to the issue of electoral reforms that so many people are calling for. How far-reaching do you think the electoral reforms should go, and how far-reaching will it be on our democracy or democratic practice?
Well, I will say that in terms of the electoral reforms, I can tell you that we are making progress. Progress in the sense that if you look at in the past, a lot of those challenges that we have been put in place, at least to some extent. So there's still a lot of room for reform, but a lot have been achieved. And for example, I'll give you an example. You know, under the ACJ Act, in a criminal trial, no court at least is allowed to entertain an application for stay of proceedings until that trial is fully completed. And I think we also need to introduce that even in our electoral reform, because one of the problems we are facing, particularly in the pre-election, I know in the post election we have issues that have actually been curbed, but in the pre-election matter, you still find stay of proceedings in the course of interlocutory hearings, and I think we also need to look for a way to stop that. If you commence an action, a pre-election matter, which you have 180 days to complete, no party should be allowed to stay proceedings to appeal. We should wait. we should finish the pre-election matter by the trial court. So whatever your disagreement with that judgment, you can then take it up to the Court of Appeal, and the same thing, Court of Appeal to the Supreme Court. Because I found out that
just one moment.
One of the major problems that we are facing now.
Just one moment, Mr. Dry. Are you talking about the pre-election matter or post-election matter now? Because
no,
we know
post-election now there are no stay of proceedings.
Okay,
you have to finish, and
yeah.
lot of your objections had to be you just file. Everything will be considered at the end of the case.
Now, in recent history, some people have argued some of the judgments that we have had, even about gubernatorial elections, some of them have been as a result of pre-election matters that should have been determined before the elections. In that regard, what should happen? Should the elections be postponed before the issues are resolved?
No. I think that is it's very difficult thing that maybe we need to go back to the drawing board, because don't forget that the Electoral Act conducts and stipulates the time when you will conduct your primaries, and between your primaries to the general election. And of course, you won't find anything that you want to take up until after the primaries, because you don't even know the candidate of the party until the conduct of the primary.
Does that then suggest that the law itself is culpable or needs to be amended to address this issue?
Yes, again, you also have to look at the reality of it. At what time? Oh, because what do you complain in primaries? In pre-election matter, what are your complaints? Is either against that party conduct or against the candidates. So you find out that you will not have any serious or any pre-election matter until most of these steps are taken. So except you want the party, and that means we will amend our laws so that we will know the candidates of the party maybe a 1 year ahead, so that when you calculate the 180 plus 60, that gives you about 300 days. So that means that it's only in that instance that you'll be able to complete pre-election matters before the election takes place. And I don't know how that will sound. But I think in whatever circumstances that we are, what is important is that at least you know that in your pre-election matter, within 300 days, you will know your fate.
You know, all this eventually now leads to the point where you talk about technicality or substantial judgment. And that was also an issue yesterday. And I'm wondering, can you really have judgments? Can all judgments really make sense to the public?
Well, yes. Yes and no. You know, sometimes when you say, for example, now that a lawyer these days may look at a judgment and understand the basis. The same lawyers may look at another judgment and probably may not even understand why the court has come to this judgment. So for me, it all depends, and from the sides that you are looking at it from. So it all depends. But I think our courts, we must give it to them. And in fact, the recent amendments too, that we're moving from the time of technicality to substantial justice. You know, sometimes too, even what we call technicality is even the justice. Because, I mean, if the law allows you to do certain acts within certain period, and you don't do it, I have the right to object to it. But it will sound as being technical, because what you are trying to do is probably to ensure that maybe that issue doesn't go to court, or when it goes to court, it is knocked out. You may depending on the side you are looking at it from, you say, oh, this is technicality. But in another way of looking at it, it also amounts to justice. Because if you sleep on your right and you are expected to act and you refuse to, you shouldn't even come tomorrow and complain. So I think it depends from the sides that we're looking at it. But I know that our courts are moving away from technicality now to substantial justice.
Clearly, it's hard to find a simple answer in law, really. You'd always have here and there, and I mean, that's what law is about. But let's see if we can get some simple answer to this next topic, and it borders on security. There's been a lot of debate about state security, state police, community police, who has the responsibility under law to do what should we do moving forward to address a clear challenge, which is the security situation in the country. You may have been following this this debate about community police, the Southwest governors, other governors, what the police is doing, what the governors want, what the communities want. What do you see as the way forward for this, whole debate about state police?
Well, for me, I think the clear answer to all the problems is that let us, as a country, practice true federal system of government that we profess. You see, you will find out that we say we are in a federal system, but you'll find out that most of the things we do not support federal system of government that we claim we operate. So, for example, now, if truly what we are practicing is federal system, there's nothing stopping the state from having their own state police. And it's only when you allow states to have their own state police that you will at least reduce the issue of this security threat. But where you have to wait everything from the federal government, you don't even have powers that a state commissioner, and I'm going to give you an example, and I won't mention states. We have a commissioner of police where there are challenges in that state, and then with clear evidence, he approaches the state CP, the state functionaries, and said, look, we have issues against these numbers of people. This is what they have done. Please investigate with the possibility of prosecuting where you find out that they have committed those offenses. And you'll have a CP that will tell you, you need the directive from the IG. Then you are in problem as a state. So you will find out that except and that is not the system that we profess, that we practice. So you will find out that a major problem is facing the reality. And unless we tell ourselves the truth, I don't think we are going nowhere. We just be in the same circle.
Yeah, Mr. Odubela, we are the Federal Republic of Nigeria. As you said, that is our profession, and that is what is in the Constitution. So, on the one hand, we are the Federal Republic of Nigeria. Consequently, there should be different levels of authority at the different subnational and the national levels. But on the one hand, there are a list of things, including the police and several other security agencies that are exclusively under the purview of the federal government at the center. We cannot have state police if that is the case. What do you suggest? Some people have called for a constitutional review to accommodate state police and all of that. Is that what you're also suggesting?
No, certainly. Because even by even putting police in the exclusive list is even wrong in the first place. Except what we are saying is that we're in a unitary system of government. If we're in the federal system of government, security is very important, because without security, I mean, we're going nowhere. If we say that we want people to come and invest, we want economic buoyancy or economic prosperity, and our security is nowhere, then we're going nowhere. No investors will come to Nigeria to invest. Security is very key, and our justice system. These are two major things that we must take seriously if actually we want people to come and we want economic prosperity in our country.
Now, to take it seriously, Mr. Odubela, what do we need to do now? It would seem like we're paying lip service to these issues. We have the National Assembly that is supposed to be independent, the state houses of assembly that are also supposed to be independent. We have had a number of efforts at reviewing the Constitution, which has never gone through to make some of these things that you're talking about possible. So then, who would you say is culpable here, or are we just dancing to the winds?
Well, if you ask me, I will still tell you is the executive arm. Of course, we say there are three arms of government and there are separations of powers. You see, again, I think the lead team here is the executive. For example, now, even if we say we want to amend the Constitution, of course, the work to amend is the work of the legislative arm. And of course, I'm not saying that even the arm itself cannot begin process or initiate process of amendment. But I tell you that the executive, for me, is a leading arm. For example, they have the resources. And it is from their resources that they will distribute to the legislative arm and they will distribute to the judicial arm. So I think they need to take a lead. And I believe that once they take a lead and they bring the representatives of the people, which is legislative arm, and say, look, oh, this is what is good for our country. I think that's where lies the solution. Somebody must take a lead.
Right.
And then go to appropriate quarters.
Right. You have raised the responsibility of a legislative arm of government, which will be key in this process. But a lot of people have proffered solutions. The governor of Benue State, for example, said that, let responsible Nigerians carry guns. The IGP has said several times that if you carry unapproved firearm, you will be prosecuted. And just yesterday, the governor of Ondo State says, well, Amotekun, for example, they need more firepower because when they go on the field, the kind of things they meet with, they definitely need better firepower to try to curtail that. So this conversation about gun ownership in Nigeria, it's kind of new, but what is the way around it?
Well, I think the way around it is still the issue of state police. You see, why did the state push for Amotekun, for example, the Southwest state? Is because the security is getting worse in the Southwest. And they believe that if they leave it that same way, I mean, it could even cause serious chaos. Because people now would say that if the state or the government that have the responsibility to protect our interest, to protect the lives and property of this country are not doing it, then let individuals now protect themselves. But that is not good for us. Because we also must commend the police for what they are doing. But they need to do more. They need to do more, and they should allow the state too, because it's about complementing the efforts of the federal government. If we allow,
so Odubela, just one moment.
Of government,
are you saying that would you recommend that we should adjust the laws to allow for individuals to have firearms?
No. I don't think the Nigerians that I would say I know to some extent, or the country that I know to some extent, I don't think that will portend well for us. I don't think we should allow, people to carry guns. I don't think in terms of maturity, we have gotten to that level. And I think we should still keep our hope that our government will get it right one day. So I don't believe that everybody need to carry guns. But if we allow, for example, the Amotekun and various organs like that to protect their own areas, I think that will be a compliment to the effort of the federal government.
Just one last issue before we wrap it all up. What do you think do you think there is any need for all the furore about Kama 2020?
Well, I believe so. And that is why I've been wondering where and how did we get here? I believe there should have been a public hearing at that time. Was it that it was not well publicized? Was it that people were not aware to have allowed them to also make contributions? Or was it the time that was short for public hearing to allow more participation? There are questions. But I want to believe that our government always have good intention. So I don't know. So I'm still, even myself, studying it. I know that there are certain bodies that were their advisors, they're already asking us for our advice and all that. So I think we really need to look that area and say we have gone wrong, or we have not really gotten right. And of course, I believe that there will always be a way for us to meet and sort it out.
Right.
So it's not that if that's the end of it. There will always be an amendment.
Okay.
There could be further amendments to come.
Yeah. Well, we have to thank you very much this morning for your time and thoughts. Según Odubela is a senior advocate of Nigeria. Thank you so much for your time and all the best.
Thank you for having me. All the best too. Thank you.
Well, just before we go, a few messages.
Oh, yes, we've had a couple of tweets and responses on the program and mails as well. This one from Henry Ewunonu saying that polio certification at this time shows that vaccine works. That advocacy is more effective, than compulsion of force and law, and that mischievous conspiracy theories of the elite is retrogressive. This is an opportunity in the COVID-19 response, he says.
Ayode Shurunke says, as much as I understand the concern of the FGN, Federal Government of Nigeria, and particularly the Nigeria Police Force against state security outfits, the reality is that there is nothing to fear that the NPF hadn't been used for, and there is nothing feared that the NPF hadn't been used for, and it is expedient to allow this for now and allow states to address local insecurity against IGP's preference.
Ida Peterside says, on the policing issue, why don't we hand over the present police to the state and set up a board in the state of eminent persons to oversee the police, and the center can send a police commissioner? Question right there.
Same kind of advocacy that the governor of Ondo State also raised, and as well as a number of other people. Well, we see other tweets from you, Sheya Ojabi, Ndubisi, and the rest of you. Thank you so much. Please keep them coming. And that's the show today. Thank you so much for watching, and have a wonderful day. Please keep safe. I'm Ayo Makinde.
And I'm Kayode Kikiolu. Thank you.